Welcome everyone to today's session in courts and the judicial process. Today is Thursday, April 2nd. We are continuing our coverage in Chapter 6, which is on defense attorneys. Last class, we got an introduction to defense attorneys, their role in the adversarial system. We talked about their ethical responsibilities and the delicate balance that they face in meeting those obligations, both as an officer of the court and as a zealous advocate for their client. We talked about what the role of the defense attorney is, which is not to prove the defendant innocent. A defendant is not required to prove anything. It's the government's burden of proof to prove the defendant guilty by proof beyond a reasonable doubt. And if they fail in that, meeting that burden, then the jury will be instructed to enter a not guilty verdict, an acquittal, which will result in double jeopardy attaching, and the defendant will not be able to be recharged for the same offense in that same jurisdiction as a result of that acquittal. If you were not with us, I should say, on Tuesday for that important introductory part to Chapter 6, please avail yourself of the recorded video and bring yourself up to date because I'm going to be picking up with the themes that were introduced there as we proceed today. And we will start with picking up with the plea to understand how difficult the role is and the important consequences of pleading guilty in a criminal case, the pressure on the defense attorney, clients, on the Sixth Amendment, what is the right to counsel, when does it attach, what happens when someone cannot afford counsel, and some related issues. So here we go. Hopefully this will work, and if it doesn't, we'll improvise. All right, I'm going to fast forward to 19 minutes and 45 seconds in our view of the plea. So bear with me while I buffer that up.
I was raised to believe, despite where I came from,
I could literally be anything I wanted to be.
I want to leave a legacy into Song City.
I was born and raised in Las Vegas.
I go to the University of Arkansas.
My office is the great outdoors of Alaska.
I love bringing other people together.
Excuse me.
Loving, supportive family members who push me to dream big.
ABS American Portrait. Share your story today.
Even though it was thrown out, that's still not saying you're not guilty. The DA went in the newspaper and said, even though the cases were thrown out, dismissed, they still are guilty. You know, he's still telling people we're guilty.
I believe every one of them was guilty. But I don't believe the state had enough evidence to convict them beyond a reasonable doubt.
It's hard. My children, my oldest daughter, she felt like I lied to her. Children in school making fun of her. Your mom's a dope dealer. You know. Girl. I want a formal apology. The same way, you know, that you put it out there to the world that I'm guilty of this crime. I want you to put it out there to let them know that you made a mistake.
No apology would help Irma Faye. 3 years after she pled guilty in order to go home and take care of her children, she was destitute. Because of the plea, she's ineligible for both food stamps for herself and federal grant money for education. She cannot vote until 2 years after she completes her 10-year probation, and she has been evicted from her public housing for not paying rent. Her children sleep in various homes, and she is homeless. She spends her nights outside the housing project, waiting for the morning when she can go to her work as a cook. Her job pays her $5.75 an hour.
I honestly don't believe she really understood the full extent of everything. she's a single mother, I'm a single mother. There's no way we can live without help from the government. We need that help, and you can't get that. You cannot get that if you plea after this.
My people, they were looking out for my kids, like I look out for them.
You don't deserve this. You really don't. You don't deserve it. If I would have stayed, I wouldn't have let her plea out for anything. I know I'd have made her stay right there with me. Hey, you gotta be strong. You got to be.
It's just, I don't know, I just, try to maintain, I don't know, just, sometimes I'm always, thinking to kill myself to just get away from this.
Don't do this to your kids. They look at your face and they know something wrong. Your oldest child, she knows. She's old enough, she knows. She can just look at you and tell mama something.
They saying I owe them $1,866.
She owes a $1,000 fine, court costs, and late probation fees.
They pressure me to pay this money, which they know I already have. They said like, as long as I have a job, I can pay it. I even explained to them, I'm having a hard time, I have to buy my son medicine. I have to have his medicine for his asthma. They didn't really care about that. All they wanted, was the money.
One of the corrupting influences in our courts is that many localities depend upon the courts as a major source of revenue. The speeding tickets and the driving under the influence of alcohol tickets and the money for marijuana possession and all of these crimes is to generate money. But when the courts are in pursuit of profit, that's in conflict with being in the pursuit of justice.
Irma Faye will be under probation for at least 7 more years. The fact that her case would have been dismissed with all the others had she not taken the plea makes no difference.
It's very difficult once you plead guilty. Guilty plea sort of puts a lid on the box regardless of what's inside the box. It's a system that's designed to keep the truth from coming out. Plea bargaining has nothing to do with justice. It has to do with convenience, expediency, making the life of prosecutors and defense attorneys easier and more profitable. It's designed to avoid finding out the truth. It's designed to avoid hearing the defendant's story.
Okay, again, technical challenges, but we'll try and find our way back to where we were. There we go. Can everyone hear me? Just open your mics and say yes or no.
Yeah.
Yes.
Yeah.
Can you see this? Is the PowerPoint displaying to you with slide number 38, which was that part of the plea you just watched?
No.
No.
Okay, thank you. How about now? Can you see it?
It's like half on the screen.
Okay. Is that better?
You can't really see the words now.
Is that better?
Now it's half the screen.
Okay. Bear with me for one more second. What about now?
No.
You don't see anything?
No.
Okay, thank you. What about now?
It's still on half the screen.
What about now?
I think that's fine. I can read it.
You can? Okay. Let's continue on. I just want to ask you a couple of questions. What do you think they meant with the comment about that the criminal justice system is about profit and not justice? What were they referring to?
Kind of the fact that people, when they get out of jail or prison, they can get hit with so many fines and fees that it's hard for them to succeed afterwards trying to come back into society. So they
Okay.
can make money off it, but the person doesn't really get justice for themselves because they're still trapped.
Where does that money go that they were referencing and that you just mentioned? Who gets that money? The answer is that money goes to either local or state government. This is not some private profiteering. This is the government having a source of revenue from poor people to help support services in the community. It's just like paying property taxes. But this is not a tax. This is a fine or a penalty or a fee, which often falls disproportionately on individuals who lack the resources to pay it. You all remember the Michael Brown case in Ferguson, and part of the Justice Department investigation into that police shooting and killing of Michael Brown, who was not armed, disclosed the fact that in Ferguson, Missouri, a significant amount of money is depended upon by the city of Ferguson, collected through the courts for fines and fees. So the police who are paid that same city are incentivized to write a lot of tickets. The courts are incentivized to impose fines and fees as a way to collect money to turn over to the town, which helps the town stay running and paying their services. But these are people who can't afford a home. Irma Fay was working. She was a cook. In all likelihood, she was not making minimum wage. And if she was making minimum wage, it certainly was, this was filmed in 2004. She was probably not making $5 an hour. She couldn't afford an apartment. She had no place to live. How was she going to pay probation? How was she going to pay a fine, $1,000 fine, for a case she pled guilty to? And in order to get out of jail, Irma Fay was charged with 20 some odd other people in what turned out to be a case that was really absent in strong evidence and maybe even in fact. And so a lot of people who refused to be guilty the cases were dismissed because the prosecution could not prove the case. Those individuals, however, that were brought in under those charges with those 27 people, excuse me, bail was set, and bail was set for Irma Fay. Irma Fay didn't have money to pay for bail. She didn't have any money at all. So she sat in jail, and she would have continued to sit in jail until her case went to trial. By pleading guilty, she was allowed to leave jail, but then had to be sentenced and was sentenced to 10 years of probation, a $1,000 fine, a probation supervision fee. She couldn't afford those. That's a, it was designed to fail. There is no way she could afford to pay those. So that's what the profit and versus justice model that he spoke about relates to. What about someone else? What did you learn as a result of this video that you didn't know before? Okay, next question. In one word, how do you feel after watching the video about our criminal justice system? Okay, no one wants to talk. So I'm just going to keep on going, and that's I guess what we'll have to do. Now we turn to the Sixth Amendment right to counsel, which is obviously critical in a discussion regarding defense attorneys. Obviously, anyone who can afford to hire an attorney is free to do so. However, many people, in fact, upwards of 95% of individuals in felony cases are eligible for court-appointed counsel. So last class, for those of you who were with me, you will remember we went through and discussed some of the cases that developed over a 40-year period starting in 1932 in Powell versus Alabama and concluding, or at least culminating, in Gideon versus Wainwright. So I'm going to pick up there where we sort of left off and remind you that 1932, remind everyone that when the Sixth Amendment was adopted in 1791, it only applied in federal cases. The Bill of Rights, the first 10 amendments, only applied to the federal government. It wasn't until the United States Supreme Court began incorporating on a clause-by-clause basis parts of those first 10 amendments into the 14th Amendment, which does apply to the states. So up until 1942, there was no federal constitutional right to have an attorney appointed and paid for with public funds unless there were special circumstances, as there were found to be in Powell versus Alabama. As we move forward, after Powell, then Betts, we'll talk briefly, then we'll go to Gideon versus Wainwright. So in 1963, the United States Supreme Court landmark decision held that the Sixth Amendment right to counsel was incorporated into the 14th Amendment of the Due Process Clause, and as such was applicable to the state and local government. As a result, appointed counsel in all state felony cases became a due process right that had to be adhered to not only at the federal level, but at the state level. It was then left open to the question, okay, well, what about when in the process does that right to an attorney publicly paid for kick in? Do I have a right to an attorney the moment I get arrested? The answer is no. Do I have a right to an attorney if prior to my arraignment I'm placed in a lineup or my photo is put in a photo array, which is used to identify me, resulting in my arrest? The answer is no. So the devil is in the details. We made a lot of progress in those 40 years. Gideon certainly is championed and celebrated as a very important due process right in our criminal justice system, but there were still areas that may surprise you, which we'll cover hopefully in our time remaining today. And then shortly after, 9 years after Gideon, the United States Supreme Court was asked the question, okay, well, what about in state cases where someone is charged with not a felony, but a misdemeanor? Do those defendants have a right to an attorney if all that can happen to them is they can be placed on probation, or they can get a fine, or they can be incarcerated, but they can't be incarcerated in state prison? And the United States Supreme Court in our Singer versus Hamlin answered that question, that in any state case, whether criminal case, whether felony or misdemeanor, the right to publicly funded counsel for qualified defendants, in other words, those who the court determines are indigent, is a Sixth Amendment right for any offense that could result in incarceration for any length of time, whether it's in jail or what we call houses of corrections or in prison. Okay, so we're going to turn now to the Scottsboro case, the case which opened the door to the Sixth Amendment being applicable to the states. And I should point out that some states, under their state constitutions, did recognize a right to counsel for defendants in state criminal cases, but not all states. In the Scottsboro case, 9 Black teenagers were falsely accused of raping 2 white women while on board a train near Scottsboro, Alabama. It's 1931, so it's Depression era. It's Deep South, and highly racially charged. Certainly segregation, de facto and de jure segregation, existing in Alabama at that period of time. These boys were put on trial without really any representation of counsel at all, and they were convicted, and upon conviction, sentenced to death. It became, through the newspapers, a very high-profile case around the world, and a black eye, really, on, no pun intended, on the American criminal justice system. In this case, Powell, one defendant, and 8 of the others who were described in the United States Supreme Court decision in 1932 as young, ignorant, illiterate African American men. They were young, they were teenagers. Ignorant meaning not that they were stupid, they did not know how to read, which is also illiterate. Ignorant in the fact that they had no idea how the criminal justice system worked. They had no idea what their rights were. And can you imagine being young, black, in Alabama in 1932 and charged with a crime that carries the death penalty? And the prosecutor has made it very clear, if there were no women attorneys, certainly not in Alabama in 1932. If he obtained a conviction, which he was quite confident that he would, they would receive the death penalty and they would be executed. They asked for an attorney, and the trial judge, the judge that was going to hear this trial, appointed no person in particular, but requested all members of the Alabama bar to step up and represent these kids. 6 days later, when one attorney and a Tennessee attorney came and volunteered to represent the 9 kids that were going on trial. 6 days, no time to prepare. Neither one of them had any death penalty experience. One of them wasn't even licensed to practice in the state of Alabama, but was allowed to under these extraordinary circumstances. They were all tried. They were all found guilty and all sentenced to death. You may be familiar with Harper Lee's very famous and well-loved book, To Kill a Mockingbird. That book is roughly, loosely based on the facts in this case. The defendants appealed their conviction. Their convictions were overturned, and the United States Supreme Court ruled the state of Alabama had violated all of the boys' Sixth Amendment right to counsel. And I'm sorry, not the Sixth Amendment right, but they have been deprived more generally due process of law. Some of them received a pardon. The last one, the last young man to survive was Clarence Morris. He died in 1989 at the age of 76. And several years later, in 2013, recognizing the terrible travesty of justice, the Alabama Board and Alabama Board of Pardons and Paroles voted unanimously to posthumously. These guys were all dead, had long been dead. Some of them had been dead at that point for 50 years or more. They were all pardoned posthumously, and it stands as a notoriously sickening example of the prejudice and the lack of due process that was afforded to particularly people of color, but certainly people without access to power, privilege, and property. Any questions about the Scottsboro case before I move on?
So essentially, this case was just a door somewhat to the fact that Sixth Amendment rights to counsel should be had.
Yes.
Okay.
It was the first challenge in a state criminal case that got to the United States Supreme Court, and the court agreed to hear the argument that this system where state criminal defendants, even those charged with crime punishable by death, were not entitled to court-appointed publicly funded counsel. And in so taking the case, the court took the opportunity to say this is wrong. But they limited their decision in Powell. They limited their decision in Powell to say, not in every state criminal case, not even in every state criminal case that was a felony or even a capital crime, that there had to be special circumstances, such as there were in the Scottsboro boys case. They were young, they could not read or write, and under those circumstances, the Supreme Court was willing to say states must afford counsel to people in those positions. It wasn't until 1963, many years later, in the Gideon case, that the court really expanded the right to counsel in all felonies, in all state felony cases.
Okay.
Am I answering your question, Ariana?
Yes, thank you.
You're welcome. Any other questions? Okay, so we move to Gideon. This is Clarence Gideon, a remarkable story remarkable in a different way than those young boys in the Powell case, but remarkable. Clarence Gideon was charged with I can't read my notes because my printer has now run out of ink, but and I can't see my notes because they're too small, but we'll do the best we can here. So this is Clarence Gideon, white, older gentleman, and he was charged in, I believe, a robbery in a pool hall. After his arrest, he, sorry. Are you still with me? Yes?
Yeah.
You're still with me. Okay. Okay, great. Sorry, I'm really challenged this morning and really going to have another session with teaching and technology where I'm going to not be able to say what I really want to say. Okay, so Mr. Gideon was convicted. He had requested an attorney, and under the law in the state where he was put on trial, and I don't, again, I don't have my notes in front of me and I don't independently remember what state he was charged in. And it doesn't really matter, but it was a state that did not, under their state constitution, require court-appointed counsel in a state felony case. So he was charged with a felony under the state law, requested an attorney. The judge said, I'm sorry, you're not entitled to an attorney under the law in the state of whatever they were in. And the Sixth Amendment right to counsel doesn't extend to you because you are not young, you are not illiterate, and they never answered the question whether he was ignorant or not. But we learn later he wasn't ignorant. He goes to trial, he is convicted and sentenced, I think, to 5 years in state prison. While in prison, he appeals his conviction. His conviction is upheld on appeal by the state appellate court in the state that he was in. He then, and there was only one level of appellate court. So the next step for him was to file a petition for writ of certiorari, a written request or a typed request to the United States Supreme Court saying, will you hear my case? And what you see there on the slide before you is his very well written, handwritten. He wrote this. This is in his handwriting from a state prison, explaining why the United States Supreme Court should hear his case. And they grant his petition for writ of certiorari, which they do, at the time, maybe 10% of all cases petitioned on writ of certiorari were granted. His case was granted. It was heard by the United States Supreme Court. His argument was pretty simple. The Sixth Amendment is right to counsel is fundamental to the concept of liberty and freedom and due process. When you've got a government who has the power to accuse you of a crime that if you are convicted of, you can go to prison, you need an attorney. And if you can't afford one, then that's punishing people for being poor. That's an unlevel playing field. It's unfair. And the United States Supreme Court agreed with Mr. Gideon. And the full court sitting, here's their picture in 1962. You'll notice, not surprising, A, they're all white. B, they're all men. And C, they're all in their, at least their 50s. The court looks very different today, not as different as some of us would like it to look, but it's certainly no longer all white nor all male. Pretty close, but not entirely. But that's what it looked like in 1962. Those were the 9 men who decided the Gideon case. It was, whoops, sorry about that. So the question in Gideon was, should the Betts decision, which had previously been decided, that held after Powell, you have a right to counsel in a state criminal case, but only if there's special circumstances. And the court in Gideon said that shouldn't be the case. Everybody charged with felony in a state case should have the right to counsel under the Sixth Amendment. The court took its opportunity to not follow the doctrine of stare decisis. It did not follow its precedent set in the Betts case. It overruled Betts expressly and agreed with Gideon's argument. Yes, the Sixth Amendment must now apply in all, not only federal, but state criminal felony cases, unless a defendant makes a waiver. And the waiver, so defendants can be advised, you have the right to an attorney. They would be advised by the court on the record. You have a right to an attorney and some explanation about that. And then the judge would ask the defendant question, how old are you? How far did you go in school? Do you have any learning disabilities? Do you take any medication on a regular basis? Has anyone made you promises in exchange for your agreement to sign this? A few questions to establish that a person is capable to make a knowing, intelligent, and voluntary of the right to counsel. I would respectfully submit to anyone charged with a felony that you never waive your right to counsel. Look at Irma. Look at Irma Faye. What happened to Irma? She had an attorney, and look what happened to her. Imagine. I just imagine. Okay. All right. So remarkable is Gideon's story, as you can read here. And ironically, Gideon was his birth name, and Gideon from the Old Testament. For those of you who know your Bible stories, and those of you who don't, Gideon's trumpet is actually a reference from the Bible. So Mr. Gideon was a petty thief. He stole stuff, and he was arrested. He was convicted, and in the end winds up redeeming not only himself but also establishing a landmark decision before the United States Supreme Court, which bears his name, of course, his namesake. So it was Florida. I'm sorry, I didn't remember. He had been charged with breaking and entering in a pool room. So that's burglary, breaking and entering. He broke into the pool room, God knows whether it was to get liquor or to play pool or to take a nap on the pool bed, on the pool table, who knows. But, and he, as I mentioned, was convicted, sentenced to 5 years. And under the doctrine of stare decisis, the judge in the case says, look, under Florida law, you don't have a right to an attorney. And under federal law, you don't have a right to an attorney. Betts versus Brady says there have to be special circumstances, and you don't have any. So you don't get an attorney. The result is you go to trial, and no surprise he loses, no surprise he's convicted, no surprise he's sentenced to prison. Big surprise that he was able, with the strength and conviction of his own pen. This was a relatively uneducated man, uneducated in a formal sense, but very well educated. He knew what was right. He knew what was wrong, and persuaded the United States Supreme Court to change the law in this country. All right. Oh, I keep doing that. So I'm not going to show you the video, but there is a lot of, it was the 50-year anniversary of the case was decided in 1963. So the case, the United States landmark decision in Gideon versus Wainwright celebrated its 50th anniversary in 2013. In the federal courts and in the bar associations, both at the federal level and across the states, and by the Justice Department and others, there was a big celebration of Gideon. But it points out that the promise of Gideon has not really come to fruition. We do see in courtrooms every day court-appointed counsel for defendants in millions of cases every single day. Taxpayer dollars do support it, but there is real question about, and you saw it in Irma Faye's case, even with counsel, is the system designed for convenience and expediency, move cases along, get a guilty plea, just put them on probation and get going? Or is it designed for justice? Irma Faye did not get justice. Irma Faye pled guilty to a crime she didn't commit in order to get out of jail. That's not justice. That happens every day, in every place, in anywhere in the United States of America. Every day, multiple times a day. When the courts are open, which they are not, they are currently closed until May 4th, which leaves people who couldn't make bail with some very difficult avenues to try and get out of jail if they can't go back to court. That's a story for another day. Okay. So the post-mortem on Gideon is, yes, it was a landmark decision. Yes, it made a great progress, and it did close the gap between the rights of defendants in state criminal cases that did recognize under their own constitution or rules of procedure a right to counsel. But the fact of the matter remains, as published in a report done by the Brennan Center for Justice, which is an excellent resource. The average in 2012 amount of time that a court-appointed attorney spent with his or her client was 6 minutes per case. 6 minutes per case. Where clients pled guilty and were sentenced, like Irma Faye. So it's justice, but it's kind of drive-by justice, and it's a promise that hasn't been realized. Without more funds, without more public dollars to support hiring a sufficient number of either public defenders or attorneys that are appointed by the court to handle cases on a case-by-case basis, we won't have the level of resources that are needed for the volume of cases. And that's the reality. We have to either accept it or we have to change it because it's not going to change on its own. Obviously, no one wants to pay more taxes. However, as pointed out in a report done by the Harvard Law School, of the more than $146 billion spent annually on criminal justice, that's police, courts, and corrections, and that was in, I don't remember what year it was, over more than half of it was allocated to police officers and prosecutors. About 2 or 3%, so 2 or 3 out of every $100 went to public defense. 50 out of every $100 went to police and prosecutors. That's the priority. I don't know whether you think that's justice or not, but that's the reality. Okay, questions before I move on? Okay. All right. When in the criminal justice system does this right to counsel, even if you can't afford one, kick in? It may surprise you to know that not until either the initiation of formal proceedings, so an appearance in court at an arraignment, or an indictment by a grand jury, or at any other what the court calls critical stages. So what you do know as a result of Miranda versus Arizona is that when a person is arrested, is in custody, and law enforcement wants to interrogate is a very specific meaning. They want to ask that defendant, that person under arrest, questions as part of a criminal investigation, and they want to be able to use the answers or the information obtained as evidence against that person in a criminal case. In the Miranda decision, which was decided in 1966, I believe, the United States Supreme Court ruled that when a defendant is in custody, generally speaking, that means under arrest, whether they've been formally arrested or not. If they're not free to go, if there's handcuffs on them, if they're in the back of a cruiser, if a police officer's got their hands on them, they are generally in custody and not free to go. Then that doesn't trigger the right to counsel. It's only if, while under police custody, the police to ask that person questions and be able to use the information that person provides, in prosecution. So a lot of students think, oh, he was under arrest, he's got to be Mirandized. Absolutely not true. There's no right to a Miranda warning when a person is arrested. The right to Miranda doesn't get triggered unless the person is A, in custody, generally under arrest, and B, the law enforcement is asking questions and wanting to use that information. Okay, so that's where we're headed next. Oh boy. So stages, you will see there's a chart here. This is my handy dandy chart from lots of different places, but there, you will see the stages in the criminal process. If the police make a stop on reasonable suspicion, they stop a motor vehicle, they stop somebody walking, they stop somebody on a bicycle, they stop somebody jump roping down the street, whatever. If it's a stop, a temporary detention, there is no right to counsel. They don't have a right. You don't have a right for the police to say, "Oh, I'm stopping you, and you don't have to answer my questions." And you have a right to counsel. You're not going to get that warning. And if you say, "I'd like my attorney here," that's not going to be complied with because there is no right to counsel at that point. If they do a frisk, a pat down, generally for purposes of, ostensibly, for purposes of determining whether the person who's been validly stopped has a weapon, no right to counsel. General on the scene questioning, not custodial interrogation, but questions. Beginning, where are you coming from? Where are you going? How much did you have to drink? Those are general on the scene questionings in many cases. No right to counsel. Okay. Routine traffic stops, accidents, and field sobriety tests. They stop cars, every third car or every other black car or whatever. It's not based on probable cause. It's not based on reasonable suspicion. They're just routinely stopping cars and doing field sobriety tests. No right to counsel. An arrest, no right to counsel. Search incident to an arrest, no right to counsel. Booking, no right to counsel. Inventory search at booking, no right to counsel. Custodial interrogation, deliberate efforts by the government to elicit incriminating information from the person under arrest. You have a right to counsel and a right to be warned that you have the right to counsel. So the Miranda rights don't kick in until it's a custodial interrogation. If a person in custody is placed in a lineup, a corporal lineup, meaning bodily lineup, they stand up, and there's usually a screen behind them that has a big ruler that measures how tall the person is. If that in-person lineup occurs before a person has been indicted or arraigned, they have no right to have counsel present. First court appearance, first time a defendant steps foot in a court and is charged with a crime, we call that an arraignment in Massachusetts. Other states call it an initial appearance. Then the right to counsel kicks in. That's the point at which the judge will determine, do you have an attorney, Mr. So-and-so or Ms. So-and-so? Can you afford an attorney? If the defendant answers no and hasn't already been screened by someone in the courthouse in Massachusetts, the probation office, to determine whether the person is eligible for court appointed counsel, that arraignment stops right there until there's a determination made. 1, are they eligible for counsel? 2, do they want counsel? In other words, are they going to waive counsel? Don't ever waive your right to counsel. And 3, until counsel is present, that arraignment cannot go forward. Counsel has to be there. Oftentimes, what you will see, and what happens throughout every place in the United States, there's a system where in arraignments in the district courts, there's an attorney, usually through the local bar association, who gets assigned to be the attorney of the day. It's sort of like when you were in elementary school and you were like the teacher's pet for the day, or you got to erase the board, or you got to sit next to the teacher, or whatever it was. These are attorneys who are not employees of the state of Massachusetts. They are private attorneys who agreed to take cases for a minimal fee, $50 an hour, which is far less than an attorney makes privately billing. And they show up in the courts they're assigned to on a day, sometimes a day every other week, sometimes 2 days a month, sometimes more than that, depending upon the available number of attorneys. So they're there, and the judge will simply look at the attorney who the judge knows is the attorney of the day, not starter of the day, attorney of the day, and say, counsel, would you please confer with your client? It is possible for one of those attorneys of the day, a defense attorney who is going to get paid, but is only going to get paid a small hourly rate, considering all of the responsibilities he or she will have, could wind up with 5, 10, sometimes more cases in one day. And all of those people have to be processed that day. And the decisions that are going to be made might determine whether or not their client that they've never met before is going to go home or is going to go to jail. So these are not insignificant proceedings. Okay, so you can see pretty much after arraignment, anything happens, or indictment if it's a case that's brought to the grand jury. After that point, right to counsel is present. And once counsel is appointed, once somebody has counsel, whether appointed or self-paying, the police cannot ask, and the prosecutor cannot ask the defendant any questions. Can't approach them, can't ask them to come to the station and talk to them unless counsel is present. So right to counsel, very important, but there are some important stages along the way which that right to counsel does not yet exist. Okay, right to counsel if a person is indigent. Indigent means qualified. Generally, a person is qualified if they meet federal poverty guidelines. That's what we use here in the Massachusetts, and that's what's used in a lot of different states. They can't afford to hire an attorney, and we have decided as a matter of fundamental fairness and due process that in any criminal case where the defendant could be sentenced, if convicted, to any amount of incarceration, that person needs to have an attorney, and just because he or she cannot afford one doesn't mean they shouldn't get one. Because if they were to proceed without counsel, it would be unfair, fundamentally unfair. Okay, so right to counsel, that's one thing. Right to indigent counsel, I'm now going to look at the different systems that are used across various states and tell you specifically what we use here in Massachusetts. Anybody have questions before I move on? No? Everybody good? Everybody happy? If you're not happy, throw on your mic and say, I'm unhappy. It's okay to say that. I've got mine open. I'm not happy. But it has nothing to do with you. It has to do with technology. Okay, not your fault. Okay. In any case that a defendant can retain counsel, obviously they do that. And if they're dissatisfied with their privately retained counsel, they can fire their attorney and hire another one. It doesn't work that way when you receive publicly funded counsel. You may get an attorney, but it doesn't mean you have a right to choose which attorney you get. And so defendants who are indigent, who are afforded public counsel, publicly funded counsel, oftentimes will say to a judge, well, I don't think he's doing or she's not doing a good job. They haven't gotten back to me. They don't answer my calls. They don't answer my questions. I want someone else. It is not common that a judge would appoint a substitute. It does happen, but not as often as defendants would like. Okay. Throughout the United States, in at least 75% of all state cases, and in some states as much as and as much as 85% in other states, felony cases are defendants in felony cases are represented by publicly funded counsel. That's how high the dependence on public counsel is. In Massachusetts, a person who's eligible for for publicly funded counsel is expected to contribute $150, sometimes more. However, it's uncommon for a person to not have enough money to pay $150 for an attorney. And in that case, the judge can waive the fee and so as to not impose a hardship. Again, not allowing someone to have a defense attorney in a criminal case just because they can't even afford the fee, never mind the total cost, is deeply troubling, and judge can use their discretion whether to waive the fee or not. Some do it regularly, others do it more begrudgingly. Okay, so you don't have to be destitute to be able to qualify for public counsel, but it looks at actual, not potential earnings, and it looks at assets. If you have money in the bank, if you have stocks and bonds, if you have pension, if you have an income, those are all considered. It's not just income, it's also assets. Okay. So this looks at indigent defense in over 17 million state felony cases. And you can see how much money it costs, and how dependent the system is upon the use of defense that are publicly funded. So over 17 million state felony and misdemeanor criminal cases 2017 were handled by publicly funded defense attorneys. And obviously there's a prosecutor in each one of those cases. All right, 3 types of public defense systems. One is assigned counsel, one is a contract system, and one is a public defender system. The public defender system, I'll do this. The public defender system, one that you, in large urban communities particularly, there is a public defender's office for a city, any good-sized city. In Massachusetts, our equivalent of a public defender are individuals who work for the state office of counsel for, let me just make sure I get it right, it's CPCF, and I always screw it up. Well, I wrote it down and now I can't find it, and that is the story of my life. But the Council for Public, I don't know, it's Public Counsel Services. They work for nonprofit agencies who receive state funds. The feature that differentiates a public defender, or in our case, people who work for CPCS, they are full-time defense attorneys. They only, that's their full-time job. They're paid for through, mostly through state and sometimes through federal grants, but they are full-time, they work full-time. The other 2 public counsel systems are not full-time employed as defense attorneys. They are private attorneys. And there are a couple of systems. The first system I'm going to talk about is called assigned counsel. We have that in Massachusetts. As I said, in non-felony cases and even in arraignment felony cases, there's a lawyer in the courtroom, generally the lawyer who's on what they call the list, and that attorney picks up all the cases assigned to her or him that day by the judge. They receive lower hourly rates than they would if they were in private practice, and they generally make less than they would if they were a full-time public defender. But public defenders certainly don't make anywhere what the attorneys make. Another approach is rather than on a case-by-case basis, you're assigned, to all the cases that come into the courtroom either that week or that day or several days a month. There is such a thing as a contract attorney system. We do not use it here in our state. It is certainly criticized, but law firms, private law firms, can enter into a contract to say, we'll handle all your appointments for public defenders, and we'll either do it for a fixed price, we'll handle all the cases you assign to us for X number of dollars, or we'll handle all the cases you assign us for Y number of dollars for each case. This was ruled unconstitutional in the state of Arizona. We do not have it in Massachusetts. It's really roundly criticized because it really is awarding a contract to private attorneys based upon who's the lowest bidder, which means who's going to get the lowest quality. You can't make money as a private law firm if you're the low bid in a contract attorney system. So that's that. Okay, the state public defender systems, as you know them or probably have heard about them, started in LA County in the early 1900s, 1914 to be exact. Today, public defender systems represent about 70% of all indigent felony defendants nationwide. So most of this, certainly the serious felony cases in Massachusetts, those cases are all handled out of the Office of CPCS. CPCS has offices throughout, they're regional. We have offices throughout Massachusetts. They are not dedicated to just one courthouse or one large urban area, although there is a CPCS office that does most of its work out of the Boston Superior Court. Okay. The merits or the praises of the public defender system as compared to other models of publicly funded attorneys, which is either a contract basis or a court appointed on a case-by-case basis, is public defenders tend to be more experienced. They tend to be career professionals. They are not getting pushed and pulled in directions about how am I going to pay the office rent? How am I going to pay my phone bill here? Private attorneys have overhead. They have office expenses. They have paper expenses. They have staff expenses. They have telecommunications expenses. If you work in the public defender's office, that's not your job. Your job doesn't. You don't need to worry about how you're going to have enough copy paper or how you're going to be able to pay the phone bill. Your focus is on representing your clients. It is a career. There are people who make a career out of being public defenders, and they are some of truly the most dedicated, hardworking, qualified attorneys that I ever had the privilege to work with. Some prosecutors dislike the public defenders because the public defenders really make prosecutors do their job. They make sure to the fullest extent that they are able, and they're not always able, that the government's case gets tested. And it slows the process down. They make sure they get what they're supposed to get in discovery. They have the time and the resources to do it. Another critical feature about public defenders' offices is they have budgets for investigation. So if they, when they pick up a client, oftentimes there needs to be a defense investigation conducted of witnesses, of the crime scene, of the evidence, all kinds of information. That there's often two sides to every story. One side is the police story. One side might be a victim story. One side might be one witness's story. But that doesn't mean there's not more to that story. And the only way that a defense attorney can be sure on behalf of her client that that story comes out is if they have the funds to hire a private investigator to go out and get the rest of the story. It takes money. Defendants who are indigent do not have money. O.J. Simpson, when he was charged, was able to provide probably $1 million, maybe more, to his attorneys to use to hire private investigators. Most of us don't have $1 million. I don't have $1 million to spend on that. Okay. So the current controversy really remains about inequality of effectiveness. But the argument really comes down to, are we spending too little on indigent defense? If we want quality and not just, run of the mill, push them through, get them through assembly line justice, then we have to hire more people. And if we're not willing to hire more people or provide more taxpayer funds to support indigent defense, then we're going to continue to have what we got. There's no free lunch. There's no magic wand. There's no secret formula. That's just the reality. Okay. Clients, particularly publicly defended clients, whether it's the public defender's office or some other system, believe that a private attorney would do a better job. I must tell you that that's not necessarily true, but that doesn't mean you're going to convince them of that. Private attorneys, it is true, private attorneys, as a general rule, spend more time with their clients. Well, duh, if you're getting paid $500 an hour, you're going to take time to meet with your client because you're going to bill them $500 an hour. That they file more motions in court. They're in court more frequently, challenging the case more rigorously. Again, you're getting paid $500 to prepare those motions, to present them in court. You're getting paid for it. You're not volunteering to do it. If they attend more hearings, they meet with more families, that is probably true. But the reason for that is because they're getting paid at a very reasonable hourly rate, whether it's $250 an hour or $500 an hour, or there's defense attorneys who charge well in excess of $1,000 an hour. Their clients can afford it, and they get different treatment. Is it right? No. Life isn't fair, and this system isn't fair, but it's better than the system that we used to have. Those who have resources there's no, let me frame it. The words over the United States Supreme Court say, "and justice for all." That's a great aspiration. It's a great promise. It's not a reality. Many, 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 many people in our country do not have the resources with which to adequately fight a criminal case. Some do, but they are more the exception than the rule. So, representing indigent clients, both defense, whether it's a public defender or otherwise, like the prosecutor, they are overworked, underpaid, have heavy caseloads, and oftentimes not enough resources, including funds for investigation and expert witnesses. So in a case that there's DNA evidence where the scientific methods that were used, or the handling, or the contamination, or the chain of custody, or the reliability of the science on which the expert is going to testify, it costs a lot of money to hire an expert witness to come in and challenge the prosecution's view of the case. That is very expensive. Any expert witness, whether it's psychological, psychiatric, developmental, accident reconstruction, ballistics, DNA evidence, trace evidence, it's very expensive. No, there's no free lunch. Very expensive. What the evidence shows is that there really is very little difference between private and public representation in terms of outcomes. Public and private cases get dismissed at approximately the same rate, which is what the defendant wants, make the case go away. The conviction rates are, with little variation, pretty equal. Sentence lengths are, with little variation, pretty equal. Where we do see differences in outcomes, those differences appear to be falling disproportionately, not based on who the attorney is, whether public or private, but the race, the income, the criminal history, and the pretrial status of the defendant. So there you have it. Equal justice for all who can afford it. Okay, the last thing we're going to turn to, let me stop there. Does anyone have any questions? I'm going to finish out this lecture. I completely understand some of you may need to go. That's fine. I'll finish out this chapter, and it'll all be recorded for any of you that need to bump out early or need to bump out before I finish, and I may over because we only have 5 minutes left. The last piece that I'm going to cover is something called effective assistance of counsel. The United States Supreme Court has ruled that the Sixth Amendment right to counsel includes not any counsel, but an attorney who is effective. Now that sounds great, but what we're going to see is once pushed to the test of what does effective mean, effective doesn't mean what you and I probably think it means. And many defendants who are convicted appeal, or you seek a new trial before the trial judge, and if that's denied, appeal their conviction, arguing that they did not have effective assistance of counsel. Yeah, I had an attorney, but he or she fell asleep. He or she never interviewed the witnesses I gave him the list of. He or she was drunk. He or she was arrested and had to get bailed out before they got to court the day of my trial. Those are all real examples where the United States Supreme Court said, well, no one said it was going to be perfect, but they were effective. And so I'm going to turn now to the standard of effectiveness. Okay. I'm going to watch quickly the landmark case where the court decided what is effective assistance of counsel. And this is an area of great consternation, is the Strickland case. Hopefully you'll see this. This is short, very short. Do you see the YouTube video coming up? Or no?
Hi, everybody. I'm Arlene, and welcome back to an.
Can you see the video? Yes or no?
I can't see the PowerPoint.
You cannot see it.
No.
Is that what I'm hearing?
Yeah, I can't see it.
Okay. All right. Hang on 1 second. Do you see the PowerPoint? Yes or no?
No.
Thank you. Great, so now I can't get to either one of them. This is not good. Give me 1 more second. I'm not going to show the video because for whatever reason, the hyperlinking is not working. Again, perpetually, endlessly. Oh my goodness. Okay, now can you see it? Whoop. Can you see the slide?
Yeah.
Okay, sorry about that. If you get a chance, the Strickland video, the video clip on slide, I think it's 89, is helpful. But what you need to know about Strickland is this is a 1984 case in which the United States Supreme Court ruled that effective assistance of counsel was not denied in a case where the defense attorney decided not to bring in character evidence or psychological evidence in a death penalty case. The court said that was a reasonable judgment, professional judgment for the attorneys, for the court-appointed attorney to have made, and they're not going to second guess the trial attorney on a strategy, even though his client was in fact convicted and sentenced to death. And so the court set up a really high standard for a defendant to successfully argue that their attorney, whether privately paid or publicly funded, fell below the standard of effective assistance of counsel. So the defendant has to prove that counsel conduct undermined the proper function of the process, that the performance was so deficient and errors were so serious that counsel was not functioning as the type of counsel guaranteed by the Sixth Amendment. Well, I would say to you that if I were a death penalty eligible defendant, and I said there's people who can speak on my behalf, and there is psychological history here which may not excuse what I did, but it might be relevant as mitigating circumstances to move this from death penalty to life without possibility of parole, and for the defense attorney saying, no, I don't think we're going to do that. I think that's too much of a gamble. Okay. I might feel that I did not get effective assistance of counsel. Then the second thing that the defendant has to prove, very difficult to do, that the deficient performance made the outcome unfair. Was it so serious that the defendant was deprived a right to a fair trial? Is the result really unreliable? Very tough standard to make. Therefore, very few appellate courts reverse convictions on the ground of ineffective assistance of counsel. Very, very rare. As one scholar has written and chronicled, literally, lawyers who slept through the trial were deemed not to be inefficient. Literally came to court drunk, under the influence, not deemed to be deficient. A lawyer who couldn't name a single court case as precedent related to the case they were arguing. Excuse me, not deficient. The case of the person, the attorney was arrested in North Carolina for driving under the influence on his way to the jury trial to select the jury in a case. The court held that was not deficient, not ineffective assistance of counsel. So the bottom line is it's very, very difficult to prove. It's extraordinary for a court, if they're not going to rule it ineffective assistance of counsel with a sleeping or an attorney who can't cite the right law, or an attorney who's just been driving under the influence who had to get bailed out of court in order to get to court to begin to participate in jury selection, not much is going to be found to be to be ineffective. And in fact, you see on this last slide, ineffective assistance of counsel claims have been denied in cases where the attorney was disbarred, lost his license to practice shortly after finishing the death penalty case in which the defendant raised ineffective assistance of counsel. In cases where the defense attorney failed to investigate an alibi, someone or other evidence that could provide information that the defendant has an alibi. He wasn't there. He was with me, or he was somewhere else, or whatever. Failed to consult experts on forensic issues, even failed to show up for hearings. So it's great to say you have a right to effective assistance of counsel, but if the standard is so high and the burden is placed solely on the defendant for establishing that the counsel was present, or physically or not physically present, then it's not going to be a successful grounds for appeal or for a petition for writ of habeas corpus, which we'll talk about in chapter 13. Okay, questions before we sign off? Casey? Anybody? Any questions? Okay, don't forget your quiz is due in this class. Let's see, today is Thursday the 2nd. It's due on Saturday the 4th by 11:59 p.m. It is longer. It's 45 questions. You have 90 minutes. And hopefully it will go as well as the past have. The grades on the quizzes have been pretty remarkably high. So if you do have any questions and you want to reach out to me by email, that's fine. I'll certainly get back to you. Otherwise, I'll see you on Tuesday at 9:30. And in the meanwhile, I'll be visiting my friends in Teaching and Technology Center to figure out what is going on. I don't know that I'll have an answer, but I'm going to try. So see you next week, guys. Stay safe. Bye.